Okay, thank you, everybody. Our next speaker this morning flew in just for this session. We're very happy to have her here. Actually, Ken and myself have been talking with Karen as well as Kathy Wilson at the Wheat Commission on this topic for a couple weeks, and knew it was one that could always help by setting the facts of the table, that some things are not always as well understood as they could be around seed as intellectual property. So that really, guys, is the grounding for this morning's session on this. So from the University of Idaho, please welcome Karen Stevenson. Thank you.
Cool. I won't wander away from this. Yeah, we have the first slide up. First of all, I just want to point out my email. I may not be able to answer all your questions, or if you come up with another question, feel free to contact me anytime. Send me an email. If I don't know the answer to it, I can contact the Plant Variety Protection Office, our attorneys. We'll find that answer for you, before things get awry and people get in trouble with brown bagging and all that kind of stuff. What? Oh, dang. Okay, so as I was researching on this topic, I wanted to let you know that we started from a foundation of free seed. So this is in our DNA, that farmers got free seed for growing. And actually, we went through a whole process on that. It wasn't until about the early 1900s that companies decided that they could make money off of seed and plants and wanted more protection around that. So, I'm going to go back a second. So by 1941, 48 of the states that existed then all came up with their own seed laws state-wise. Now we had the Federal Seed Act. What was happening is there's little modifications for each state, and so the federal government had to come in, pass this Federal Seed Act to try to coordinate between states, so because of interstate commerce and commerce overseas. So I'm not going to go into any more detail on that, but just that that's how it happened. Okay, I want to talk a little bit about the utility patent. I actually have it right here. So utility patents. We also, as a country, part of our foundation was utility patents. You could see the Utility Patent Act passed in 1790. So this is part of our foundation. Of how we were and grew as a capitalistic country, that you were able to get 20 years to exclude others from practicing your invention, and then it would go into the public domain. Now, plants at the time were eligible, and both seeds sexually or asexually were eligible in plant cuttings. But the problem with the utility patent, it was just too stringent, and they needed a little loosening of the laws to have good plant patent, and what I'll talk about next will be the PVP. But with the plant patents, you'll hear the word, somebody has a plant patent, that's for asexually produced babies, like an apple tree. All your apples out there are plant patent. A plant seed does not, apple seed does not plant true. You have to have graftings. A lot of people who got plant patents were rose bushes and other types of shrubs that wouldn't breed true if planted by seed. And now, if you notice, by 1980, when 1980 happened, this is when the world started opening up for GMOs. And we also call them genetic engineering. And again, we're finding, as I'll talk later on, it's increasing more and more every year, people entering into the genetic engineering GMO world. Okay, this is probably what you're most interested in. And this is the Plant Variety Protection Act. And that only came about in 1970. This is as far as the other intellectual property protection, the utility patent, the plant patent. This is a young player in the world. And it's gotten through some bruises, legal discord in it. Because when it started, they tried to keep their rights to brown bag and sell to their farmer neighbor, and also to sell certified seed. The PVP is seed protection. So the plant patent is asexual, the PVP to seed protection. Again, it came about because the farmer, the company, they needed a way to protect seeds based on phenotype. So that's what it is, it's phenotype. How does your wheat do? How does your barley do? What does it look like? What color, yield, all of that stuff. Many of you probably have planted the BASF Clearfield wheat. BASF Clearfield wheat is actually a phenotype, but it's embedded as a utility patent within the PVP certificate. So the University of Idaho sells Clearfield wheat. You know of UI Magic, UICF Brundage is one of the first generations. So within that variety, in the PVP certificate is embedded a utility patent number that belongs to BASF. So our bargain with BASF in developing that variety is we have to split the royalty in a certain way with the BASF. In more recent varieties like UI Magic, because we have a partner, in this case is Lima Grain, those royalties are split in a certain way between BASF, the University of Idaho, and Lima Grain. Okay, let me do something different with the PVP. PVP protection, when it began, lasted 18 years. This is one thing in the growing thing of changing in the PVPs. This is so much better than what we have in utility patents. Is PVPs, once that PVP certificate issues, there is 20 years of protection, and then it's essentially off patent. There's a few things, 25 years for vines. Don't ask me how that happened, but it did. Okay, these are what you can sell them as. So you have two options. The owner, say the University of Idaho, the owner has two options in their PVP certificate. You have one way you can sell and do brown bag and certified seed, or what they call Title V is only limited to certified seed. Now you'll probably want to say back up, the UI varieties are public varieties. We have a couple of levels. We have UI varieties that we hold in our foundation seed program that you could buy directly. They're not PVP protected. They're a free-for-all. We have the next level. It's PVP protected, Title V, but you can only sell certified seed. But the catch with that is you do not owe any royalty to anybody. Those are public varieties. So that's what they meant by public varieties. Now they started doing this before I came along at the university, and so I can only guess as to why the university and the Wheat Commission wanted to do this. And I think it was to protect the integrity of the varieties. That if something really went wrong, there was a way that the university and or the Wheat Commission can reach in. It wasn't a way of trying to keep people from growing and selling the certified seed. Again, that's my guess. Now, this is where I had jumped ahead to, and I apologize. I was so excited to jump ahead to this. So in 1970, when the act was passed, you as a grower could brown bag and sell to your buddy, or you can sell the certified seed depending on if it had Title V protection or not. In 1994, the PVP Act was changed to line itself with international law. And that's when we actually picked up protecting potatoes by PVP. But what happened is, if it's Title V, you cannot brown bag and sell to your neighbor. You can only sell it as certified seed. So there's an exemption in this for people doing research and development, that you can take a variety, you can put it into your breeding program and come up with a new PVP variety. This, I have to tell you, is what industry hates right now. And what I'm seeing coming through in some of the research that we're doing on new varieties with maybe new mutation traits is they are trying to hold us from not being able to use their variety in our breeding program. For instance, say we get a new variety and we come to an agreement that we're going to use this one, I don't know, I'm going to still stay with glyphosate. So it's a new glyphosate-tolerant variety. There's a new gene in there, and we can use it in our breeding program to have that variety in it. Now, say that variety drops out, and we don't have that trait in there anymore. We are not allowed to take the rest of those seeds and put it into our breeding program. We're being more and more restricted by legality precisely because they were trying to, people don't like this. They don't like that people could do independent breeding. Now here I wanted to point out is you'll see a lot of folklore. It says farmers only allowed to plant in an area no larger than area originally planted. Well, it is sort of folklore, and it isn't. I go back, I thought, well, geez, what's happening here? Well, we go back to the law. This is the law. This is what's on the USDA website, and the law says production of a crop for use on the farm of the person. It says nothing about number of acreage. It doesn't limit you to a lot or a little. What limits you, what had happened, is the year before this law came into effect, there was a Supreme Court ruling. And it was through the Supreme Court that you are limited in the amount of acreage, that you can replant on your farm. So, and here's another dispute, is right in here is own or rent. Oregon State University says you can rent the farm and be the owner and replant. There are other parties that say, well, no, you have to have deed to the land to replant seed. So there is still more dispute on that end. Okay, so sorry about all this. I'm kind of rumping through. Because we have, I had some questions the other week about PVP versus plant patents, well, but it's actually utility patents. I wanted to go through who's been busy nowadays on PVP versus utility patents. And this is just for wheat. This is just 2 years. These are the top filers. So you had the top filers, Pioneer Hybrid, the Monsanto, Syngenta, and Lima Grain in 2017, 2018. These are for PVP applications for wheat. Now you go down, it's the same, I just picked up the same companies and said, who are they busy doing utility patent applications? Well, the only one really, these 2 years, really busy doing utility patent applications is Monsanto, which is now Bayer. Now, if I back up, I had somebody ask me, well, Westbred is doing a lot of filing. Well, Westbred does a lot of the marketing, the varieties are labeled WB, but it really was Monsanto as the variety owner. And now it's, I don't know if they're going to switch over to Bayer or whatever change takes place. Now, again, these varieties are all mutation. Let me get to here this is a breakthrough. This is Pioneer Hybrid. They're reading the tea leaves. They're anticipating that GMO will be approved in the US. We call it genetic engineering. They're filing. They filed this one first one in 2017 and then 2018. They're investing a lot of money in filing wheat varieties that are modified by Talon, Zekefinger, CRISPR. I guess you kind of hear that in the buzzwords in the news. So I think they're playing their card. They're the only one right now doing genetic engineering filing for utilities, but it's going to happen. Okay, let's go to a few disputes. Syngenta's been very busy. I just picked up a couple here. So this is PVP. This is where they're catching people on brown bagging. And they are going after them to tamp down on that. The latest one was 2016. And the settlements are not large. It's not like utility patents. The fines, the federal government fines aren't that large, but I wouldn't try to brown bag. So again, these are cases that they won. Here's a case, I call it closer to home, because it's our variety. And so we licensed it out exclusively to a partner that then sublicensed it out to growers who then not sublicense, but then they contract out to growers to grow. So you got UI, a company, a sub-licensee, and a contract grower. So you got 4 levels. And then rolling back up, the sub-licensee only wanted 3/4 of the crop, and the poor guy at the end of the line had seed that they could sell, and they just sold it and didn't, a certified seed, but they didn't pay royalty because it wasn't followed all the way up back the line. This was resolved, but I find it confusing. So if I find it confusing and I deal with intellectual property, my answer to you is, if you know the variety and you know it's UI variety, or a company or like a Westbred or Syngenta, even if you can't get a hold of who's selling it to you, call the main company who owns the variety. Ask them the question of can you release it one time only? Can you sell it as uncertified seed? I've had a difficult year. There are allowances that the breeder can do to help you out on extenuating circumstances. So again, when in doubt, ask. It's an integrated topic. So anybody got a question?